Good morning, this is your Kelso Report for Wednesday, November 2nd, and I'm your host, Clark Kelso. Well, the Ninth Circuit got off to a rocky start in the United States Supreme Court's 2011 term by being reversed in a per curiam opinion involving a petition for writ of habeas corpus arising out of a California case where a grandmother was convicted of assaulting a child resulting in death. The sole question was whether the 7-week-old victim, who was in the physical custody of the defendant, died as a result of sudden infant death syndrome or whether she died as a result of shaken baby syndrome. There was 7 days of expert testimony on this question, with 3 experts from the prosecution and 2 experts from the defense. The jury found the defendant guilty. The conviction was affirmed in the California Court of Appeal, and the California Supreme Court denied review. A federal magistrate and then the federal district court rejected the petitioner's habeas petition, which asserted that there was insufficient evidence to support the conviction. But the Ninth Circuit reversed and directed the district court to grant the habeas petition. Now, under the strict standards of the Anti-Terrorism and Effective Death Penalty Act, federal courts have no power to afford relief unless the petitioner could show either that the California Court of Appeal's decision affirming the conviction was contrary to or involved in unreasonable application of clearly established federal law, as reflected in the holdings of the Supreme Court, or that it was based on an unreasonable determination of the facts in light of the state court record. Now, under these unreasonableness standards, essentially a federal court can set aside the jury's verdict on the ground of insufficient evidence only if no rational trier of fact could have agreed with the jury. The fact that a federal court may simply disagree with the state court's findings is not enough. The federal court may intervene only if the state court decision was objectively unreasonable. Given the extensive expert testimony that was presented to the jury, the United States Supreme Court easily concluded that the Ninth Circuit had overstepped its bounds in reversing the district court's denial. It seemed clear to the Supreme Court majority that the Ninth Circuit simply came to a different conclusion about the cause of death and the grandmother's resulting culpability. But that is clearly not enough to warrant granting a request for habeas corpus under the Anti-Terrorism and Effective Death Penalty Act. Justice Ginsburg authored a dissent joined by Justices Breyer and Sotomayor, and the dissent is actually pretty telling about what was really going on in this case. Ginsburg did not really disagree that the Ninth Circuit got it wrong. She simply objected to the fact that the Supreme Court granted review at all in the case, since the per curiam opinion did not involve any new law or conflict in the law or anything other than simple error correction. As Justice Ginsburg properly noted, error correction is not usually a basis for the Supreme Court granting a cert petition and committing its precious resources to case review. But in reality, this case is not about simple error correction. This case is about the Supreme Court trying to discipline a rogue panel of the Ninth Circuit, sending an unmistakably strong signal that the Supreme Court is not going to tolerate the Ninth Circuit's passive-aggressive behavior in habeas cases. The last paragraph of the majority opinion notes that the Supreme Court had vacated and remanded this case twice before, calling the panel's attention to the necessity of deference to state courts in habeas cases. Each time, according to the majority, quote, the panel persisted in its course, reinstating its judgment without seriously confronting the significance of the cases called to its attention. Its refusal to do so necessitates this court's action today, close quote. And so, the struggle between the Ninth Circuit and the Supreme Court in habeas cases continues. It does make one wonder how many reversals it is going to take for the Ninth Circuit to get the picture that the Anti-Terrorism and Effective Death Penalty Act really has changed the rules in habeas cases. And now our one-liners. First, in the area of criminal law in United States v. Sanchez, the Ninth Circuit reversed the defendant's convictions for importation and possession of cocaine on the unusual or rare ground that the prosecutor's inflammatory remarks delivered at the end of his closing rebuttal argument were improper and prejudicial. The defendant had testified that he knew he was driving a vehicle containing drugs, but that he had done so under duress because drug traffickers in Mexico had threatened his family. At the very end of his closing rebuttal, the prosecutor commented on the duress defense as follows, quote, "Why don't we send a memo to all drug traffickers, to all persons south of the border and in Imperial County and in California? Why not our nation while we're at it? Send a memo to them and say, 'Dear drug traffickers, when you hire someone to drive a load, tell them that they were forced to do it.' Why don't we do that?" Close quote. Although defense counsel failed to object, the Ninth Circuit held that this argument constituted plain error and was clearly prejudicial given the somewhat weak evidence in the case on duress. The panel emphasized that this closing urged the jury to convict the defendant for reasons wholly irrelevant to the defendant's guilt or innocence. Of course, some would say that was mere rhetorical excess and strong advocacy, but in this case it apparently crossed the line for the Ninth Circuit. Next we have a search and seizure case in People v. Robinson, where the issue before the First District was whether testing a key in the front door lock of a residence without a warrant constituted a violation of the Fourth Amendment, such that the information obtained by testing the key, that is, whether the suspect was connected to the residence, could be considered in applying the independent source doctrine. There is a split of Federal Circuit authority on the question of whether inserting a key into a lock even constitutes a search, but the First District ultimately avoided that question by holding that the privacy intrusion in inserting a key in a lock is so minimal that it constitutes a reasonable search under the Fourth Amendment notwithstanding. In the circumstances of this case, knowing that the key fit the lock would have been sufficient information, combined with other facts known to the police, to secure a warrant to search the residence. So, evidence found by police officers who actually had entered the residence without a warrant after turning the key in the lock was admissible under the independent source doctrine. There does seem to be an element of bootstrapping in this case, because the holding suggests as a practical matter that if the police have a key to a house, they can enter the house before securing a search warrant. Absent exigent circumstances, it is not at all clear that this is a fair application of the independent source doctrine. Another criminal law case in People v. Nunez. The Third District held that where a defendant is convicted both of criminal street gang activity and one or more other felonies, where the other felonies are the felonious criminal conduct of the gang that is used to establish the charge of criminal street gang activity, it is appropriate to punish those crimes separately. And Section 654 of the Penal Code, which prohibits multiple punishments for the same criminal act, does not apply. Now, this is a fairly close case because Section 654 of the Penal Code has been given a range of interpretations over the years. There was both a concurring and dissenting opinion in this case, and I think it'd be a good candidate for Supreme Court review to try to bring some clarity to this complex area of criminal law. When you've got the two felonious underlying crimes being treated as separate from the street gang allegation on which is based entirely on those two crimes, you do have some confusion in legal doctrine. Next, we have a health law case in Conahan versus Sebelius, where the Ninth Circuit upheld the Medicare Appeal Council's ruling that Kaiser Foundation Health Plan was not required to pay for the decedent's liver surgery. The decedent suffered from cancer of the liver, favoring cancer of the bile ducts. Kaiser's tumor board determined that complete removal of the tumor, which would involve removing up to 80% of the decedent's liver, could leave too little liver for survival, and that surgery would not eliminate the possibility of cancer recurrence. So the board recommended that the decedent undergo a form of chemotherapy known as chemoembolization to shrink the tumor. The decedent consulted with a different physician who is unaffiliated with Kaiser, and that physician removed approximately 70% of the decedent's liver. She suffered post-operative impairment of her brain and liver function and remained in the hospital for approximately 3 weeks. She asked Kaiser to reimburse her nearly $150,000 for the surgery, claiming that their failure to reimburse constituted a failure to make its medical services, quote, available, accessible, and adequate, close quote, as required by federal regulations. The Medicare Appeals Council found that Kaiser reasonably decided surgery was not a viable option, and that an alternative course of treatment was advisable. In these circumstances, there was substantial evidence to support the Appeals Council's conclusion that Kaiser had in fact made its services available, accessible, and adequate, and the Ninth Circuit affirmed the denial of the requested reimbursement. We have another insurance law and insurance coverage case to close today in Oglio Entertainment Group versus Hartford Casualty Insurance Company. The Second District held that an insurance policy issued to an independent music label to insure against claims alleging, quote, advertising injury, close quote, did not cover a claim that the music label had actually unlawfully copied another artist's style and product. Advertising injury refers to injuries arising out of copying a person's or organization's advertising idea or style of advertising. But that did not apply when the claim against the insured was that it misappropriated the underlying product being advertised. And that's it for today's Kelso Report. Have a great day in the law.